Welfare Rights Centre. Welfare Rights Centre is a community legal centre. We specialise in social security and family assistance law. We provide information and referrals and legal representation to thousands of New South Wales residents each year who have a problem with Centrelink. Our peak organisations are Community Legal Centres New South Wales, Community Legal Centres Australia, and Economic Justice Australia. We work directly with Economic Justice Australia to advocate for law reform by sharing our frontline casework experience with the national network of social security advocates. And we do so in order to improve the social security system. We're constantly working towards making it fairer and just. As a disclaimer, I just want to remind you one more time that the presentation is general information only and it's not legal advice. And so that is why we cannot answer questions about specific circumstances. So please keep your questions broad in the chat. And now I'm going to hand over to Donna. So welcome, Donna.
Oh, hang on. My slides have, there we go. Good afternoon, everyone, and thank you for joining us and coming along. As Thea has already said, we really appreciate that you are hoping to learn more to support your clients with their issues with Centrelink when they're experiencing family and domestic violence. So this is a broad brushstrokes look at a lot of the different things that your clients may be experiencing. It's to let you know what might be out there, what problems they might be facing, and to alert you when you might be needing to try and learn more or to get some more assistance or advice. It's not possible in 2 hours to make you social security experts. All we can do is give you an idea about what sort of issues might be there and the sorts of help you might be able to give people. So we're looking at how Centrelink defined family and domestic violence and those issues that people experiencing family and domestic violence might face, including whether they're a member of a couple, when they've got care of children, when there's issues with the care arrangements of the children, things like those one-off or more, less common payments like crisis payment, special benefit, and those problems that people can have following them for years, like debts, and how to appeal something when there has been an issue with Centrelink. So we will start with how Centrelink defined family and domestic violence, because that's going to be a really key component in how you're going to be able to help your clients and the sorts of help that you might be able to, that they can get. So there is a document called the Guide to Social Security Law. It's a policy document that's published on the website that everyone can access, and it gives you some really good information about how Centrelink make decisions. And on this document, it's got a really clear definition, a really good list of the different things that Centrelink will look at and will consider family violence and domestic violence. And family violence occurs with relatives, guardians, kinship groups, any family-like relationship. But remember, it also is flatmates, and it's also friends and former friends. It's not just those intimate partner relationships or those blood relationships. Domestic violence occurs between two people where there has been that current or previous intimate relationship. They've also expanded what is considered to be family and domestic violence and the sorts of actions and the behaviours that can be looked at whether it's when looking at whether there's something family and domestic violence related. So it's not just the physical violence, there's the emotional and psychological abuse, verbal abuse, financial abuse, which is critical when Centrelink is financial support. So looking at that financial abuse in that relationship. But there's also the forced marriages, the sexual assault, the neglect, the exposing children to the behaviours. It's using systems in order to perpetuate that abuse. So using the police and using Centrelink against a person is formally recognised as a part of family and domestic violence. So looking at it really clearly about how they define family and domestic violence, domestic and family violence usually refers to threatening, coercive, dominating, controlling, and abusive behaviour. It is those relatives, guardians, kinship groups, or other family groups, and those family-like relationships like carers and support workers. And it's also those current and former friends. So in that economic, financial abuse, like withholding or taking control of a person's money, is one of those forms of abuse that's recognised. So we know that domestic and family violence occurs between all genders and in all sorts of relationships. We've popped this slide up here just to give you a bit of an overview of how it can be seen in New South Wales. We will point out that it does focus mostly our session today on families and couples with children, but it can be translated to all sorts of different relationships. And we hope that everyone helping everyone experiencing family and domestic violence will get something useful out of today. So these are statistics from earlier in the year. Obviously, there is a very large impact on women, and today is the International Day for the Elimination of Violence Against Women. But there are a lot of other people that are impacted by family and domestic violence in New South Wales. So when we're looking at Centrelink and we're looking at family and domestic violence, these are some of the common issues that are experienced that you might see coming through your organisation. Perpetrators hide income. Well, they force that non-reporting of income to Centrelink, and this can result in debts, can result in prosecution. It can be that people are unable to leave a relationship because they have no financial support. They've got no independent financial means at all. This can be impacted by their residency status, or there's all sorts of other things that might lead to this as well. It might be that they are completely ineligible for a payment due to the perpetrator's income and assets. It might be that there is an incorrect payment or rate that someone's received because of who's got the kids and where the kids are. And that can change what payment you get, the rate of payment. It can lead to debts. It can lead to all sorts of issues. It might be that they've had a reduced rate of payment because the perpetrator is considered to be their partner, but they're not getting that financial support. Or it could be that Centrelink is being used in order to perpetuate that domestic and family violence, that systems use. You know, they might be falsely reporting care of the kids, and that can impact someone's access to payment. So one of the things that we'll talk more about at the end, but you can ask that a Centrelink social worker get involved and contact the client and have a chat to them. So, member of a couple, it can be a really key part of how Centrelink will treat you, what sort of payments you can get, and what the issues might be. So Centrelink have a definition of who is a member of a couple, and it can impact what payment you can get and what rate of payment you can get. And the income and assets of both members of a couple are used and assessed when looking at what you can be paid by Centrelink. So both parties of the relationship need to be assessed by Centrelink. And so when you're in a relationship, it becomes critical. And if you're in a relationship, there is that intersection with domestic and family violence because people don't declare that they're in a relationship, so they get a higher rate of payment. Yeah. It might be that they're coerced into not declaring, or relationships are really complicated and they might not realise that they're actually in a relationship for Centrelink purposes, even though maybe they don't consider that they are. It could be that the partner's income and assets aren't being declared. Maybe maybe they're being hidden, or maybe they're being forced not to. It could be that they're just getting no financial support whatsoever. The perpetrator might be stealing money. Or it could just be an on again, off again, on again, off again, and keeping Centrelink updated with the changes just becomes almost impossible. So how does Centrelink actually define a member of a couple? they look at 5 different factors, and they look at all sorts of different aspects of the relationship under these 5 different headings, and they go, well, what does the picture create? Does it look like a relationship or doesn't it? Yeah. So they look at what the financial aspects of the relationship. They look at how the household runs, who does what, how people are working with each other. They look at the social aspects of the relationship. So what's that outward facing view? What are they telling people, other people out there? How are they presenting themselves to the world? How are they outside the house? Are they spending time together? They look at the sexual relationship between the people. Merely having sex isn't enough. That does not mean that you're in a relationship. That's only one part of all of the different aspects. And they look at how the 2 people are committed to each other. What are their future plans? How are they behaving with each other, and what are they prepared to do for each other? It is a subjective assessment. So they look at the entire picture, and the person making the decision goes, considering this picture, do I think that this is a relationship or not? Okay. There's no one nice, neat question that'll go, yes, that's a relationship. That is not. It's what does the whole picture look like? Now, the questions that Centrelink officers ask when trying to work out if someone is in a relationship or not have been included in a fact sheet that's on the Economic Justice Australia website. This is a fact sheet that I pull up a lot when I'm interviewing my clients and trying to work out whether someone is in a relationship or not. I'll open this fact sheet, I'll have these questions in front of me, and I will go through these questions and I will ask my client these questions. And when I've got the answers, I'll go, well, on balance, what do I think? Do I think it's weighed more in favour of being in a relationship or not? So it's a really handy list to have. Pop to the Economic Justice Australia website, find that fact sheet. It's a really, really, really handy tool. And you'll find that your clients will recognise the questions, because these are the questions that Centrelink ask. So, however, these are all fairly clear standard questions that you might consider, but none of them cover necessarily that family and domestic violence and what impact that may have on this whole picture. So the Centrelink very clearly states that if there is family and domestic violence present in the relationship, then this can change the weight. It can make it look like actually maybe there isn't a relationship after all. So when looking at those financial arrangements, shared bank accounts, who are you leaving your superannuation to? Who's in the will? Is there a mortgage? Who pays the rent? Who pays the bills? If there's financial abuse, if there's coercion, if there's threats, and those threats could impact the financial situation, then maybe that changes the weight. Maybe that changes the picture. Looking at the nature of the household, the actual dynamics of that relationship can be distorted by the family and domestic violence, and they recognise this. The social aspects of the relationship, people can falsely present themselves to family and friends, to schools, to hospitals, things like that, as being in a relationship because of the family and domestic violence. So public presentation may not be a true reflection. There is coercive and consensual sexual relationships that can occur in family and domestic violence situations. And although it may look on the face of it as though 2 people are committed to each other, there might actually not be any of that genuine commitment if there's coercion, threats, and family and domestic violence. So you've got those 5 factors, you've got all those questions, but when you add in the family and domestic violence, that might change the weight. It might change that picture. So they say very, very clearly on that Social Security Guide, that document, the policy document that I was talking about earlier, that the presence of family and domestic violence can indicate that the person is actually not a member of a couple, even when it may otherwise appear that they are. But you need to potentially have evidence to prove that the family and domestic violence exists. Merely saying it isn't necessarily going to be enough. You're going to need that, an AVO. You'll need a Centrelink social worker to make an assessment, or you may need other bits of evidence to show and prove that that family and domestic violence exists. So we have a case study for you here. Just one moment.
Hi, Maria. My name's Daniel. I'm calling from the Welfare Rights Centre. How are you today?
Good, thanks. How are you?
I'm well, thank you. So I understand you've got a parenting payment debt. Can you tell me about that?
Yeah, it's a huge amount, about 43,000.
Wow. And what's the, I've seen the letter that you've provided to us, and it says it's for the period 2018 to 2020. Why does Centrelink say that you weren't eligible for parenting payment?
They say I wasn't single for the 3 years after I separated from my husband.
And do you know why they might think that?
Yeah, it's a real big mess, really. I shouldn't have married him in the first place, but I was under a lot of pressure from my family. Our family said we were a good match. And, our culture is very strict. So I was 18. I barely knew him. I didn't spend time with him before we were married. So how would I know what he was like?
Yeah. And what was he like?
Well, now I can see he was horrible from the start, but I just kept getting sucked back in.
Can you explain what happened?
Well, straight away when we got married, if I didn't look after his mother right, he'd get angry. And I knew he was seeing other women because I found texts and horrible photos on his phone. He's a player, basically.
Yeah. And was he ever violent?
Yeah, he was. And it got quite bad. And even though I had to call the police twice, he wouldn't stop coming. So finally, when I was 4 months pregnant, he moved all his things out, and I didn't see him until the baby was born.
Okay. You said police were involved. Did they ever issue any AVOs?
Yeah, I've had 2 AVOs, but they've both run out, and I don't have any more.
Okay. How were you supporting yourself?
Well, I used my savings, and then I applied for parenting payment.
Okay. At the single rate?
Yes, and then when the baby was about 6 months, he started pushing to get back together, and I didn't want to. So my family got involved. So I finally agreed to go on a holiday to Bali, but it was terrible because I wouldn't sleep with him, and I came home early, and I didn't let him move back in.
Okay. So was he paying you child support?
Yeah, he was, but through the tax. So because he was single on his tax, so I moved into this duplex with my dad in the other half.
Okay. And did you pay rent?
No, we'd bought half of it when we got married with my dad.
Okay. Whose name was on the title?
My dad's name was on one, but my ex and my name on the other one.
Okay.
And actually that's when I started seeing someone else. But unfortunately, one night when my ex came over for my son's birthday, I slept with him and I got pregnant. It was so stupid. Just he was being so nice, and I don't know. So I broke up with my boyfriend, and then of course our parents were saying you have to get back together now. And he had a girlfriend, so they were saying you can't let this other woman raise your children, which actually really scared me. And eventually I agreed to sell the place I was living in and buy a bigger place with him.
And did you go ahead? You said you bought a bigger place?
We did. The accountant said to buy it in joint names because it's easy to get one name off, but basically he kept seeing his girlfriend. So I just moved in by myself. He's actually never lived there, and that's it basically. I haven't lived with him for more than 3 years, but the paperwork looks like this. And of course I have my daughter, so it just looks really bad.
Yeah, I understand. Well, we'll just break a couple of those issues down one by one and discuss them in a little more detail.
So having a look at that story, and it really does look like they're separated. It looks like they're not in a relationship. You've got, he's declaring himself single on the tax return. She's receiving child support. They've not formally lived together for many years. There's a couple of AVOs. Family know they've separated. They've had other parties. They don't help each other in any way. But Centrelink have said, no, you're in a relationship and raised a debt. because when you look at it and when you look at the information that Centrelink would potentially have clear access to, they've bought a house together. After she was on parenting payment single, they've purchased a house together. They've purchased it in both their names. They left the country together. They went on holiday as a family together. And they've had a second child that was born after she was on parenting payment single. So you can see really easily why Centrelink might consider that actually they were in a relationship. And it's those other things that you're going to be needing to find and finding evidence of to show that actually they were not in a relationship and that actually they were single. You're going to potentially have to find evidence that he was living elsewhere. You're going to have to find evidence possibly for that family and friends think that they're not together. You need to be looking for how can you show and how can you prove all the things on that yes column, because Centrelink can see those things on the no, and they're pretty strong arguments. Yeah. So that's the sort of stories. That's why you're asking those questions. That's why you're looking at those things. Now, another situation that you might find yourself in or find your clients in is where they are separated, but they're still living together. It's not uncommon for people who've been living together for years to separate and not actually move out, but to stay in the one house. And Centrelink know that. They recognise that, they accept that, and they've set up systems where you can show that to them. There's a form that's linked at the bottom of this slide that is the separated under one roof form. It's where people live in the same house, but one of them or both of them have decided to separate and they've acted on it. It's not just a thought bubble they've had. It's not just an idea that they would like to do. They need to have acted on it. They need to be able to explain to Centrelink why they're still living together. Because if you're no longer in a relationship, then the assumption is that you would no longer live together. And you need to show evidence of the fact that you're no longer in a relationship and that you don't plan to resume that relationship. Now, if there's family and domestic violence involved, you can ask a Centrelink social worker to make the assessment, and they can make the recommendation to the decision maker, and the perpetrator won't be interviewed, won't be contacted, and won't be told that that's what's happening. Okay. So the thing about it, though, is if you're separated under the one roof and you're found to be separated under the one roof, then Centrelink will continue to review, and they can change their mind at any time and decide, actually, no, you've resumed the relationship, you're back in a relationship now. Or they might go, actually, you weren't ever separated. You know, was incorrect information you gave us on that form originally. You were never separated, and it can lead to large debts. Now, the final option you might have when you're helping your clients where relationship issues are one of the big factors or one of the factors involved, is that it's the one and only time you will ever find anyone in this area that quotes the legislation and the number of the piece of legislation. It's Section 24 of the Social Security Act. It seems really weird to be quoting a section of the Social Security Act, but when you're talking to Centrelink, when you're doing any of this, you are saying you'd like a Section 24 application. It's that one time you quote the section of the legislation. And Section 24 gives the person at Centrelink making the decision the discretion to behave as though someone is single, even when they're a member of a couple. So it's not a case of, are they a member of a couple or not? There's domestic violence involved. Maybe they should be found. Maybe they're not actually a member of a couple. This is, yes, they're a member of a couple. They believe they're a member of a couple. They acknowledge they're a member of a couple. Centrelink can see, accept, and acknowledge they're a member of a couple. But because of a special reason, Centrelink will behave as though they are single. And they're looking at whether it's unfair, inequitable, or unjust that the person be treated as though they're in a relationship, knowing that when you're in a relationship, you may get a lower rate of payment. You'll get paid the partnered rate instead of the single rate, or because of the other person's income and assets, you may not be able to have any access to a payment whatsoever. Now, it can be applied. It's usually applied for reasons that have nothing to do with family and domestic violence. It can be applied when there's family and domestic violence involved because they know that people can't necessarily leave a relationship without that financial support that they get from Centrelink. So if someone's receiving the single rate of payment, not subject to the partner's income tests and asset tests, they may be in a better position to actually leave the relationship. So it can be an incredibly complicated argument to make. So it's asking Centrelink for a Section 24 application. It's asking for a Centrelink social worker to get involved, but it might actually require advocacy. So it might be contacting us or one of the other community legal centres out there who do social security law in order to get some help with working out how you may be able to advocate for your client for a Section 24 application when there's family and domestic violence involved. What it means is your client might be able to get FTB, might be able to get parenting payments single, and might be able to save up enough to be able to pay a bond, to be able to rent someone else, to be able to get out and to support and take their kids with them or to support themselves. Okay. So, overview of those things, the things that we've been talking about. When you're thinking about member of a couple and you're thinking about, is my client, this relationship appears to be one of those things that are impacting their ability to get Centrelink. The three things that you need to consider, the three things that you're thinking about are they a member of a couple, or does the family and domestic violence actually mean that they aren't a member of a couple at all? Yeah. Are they living together but separated? Are they separated under the one roof? Yeah. Or is there a special reason, that family and domestic violence, why that exists that means that they should be treated as though they are single, even though they and Centrelink and everyone else believes and acknowledges that they are a member of a couple? So those are those three key things that you need to be thinking about. Okay, does anyone have any questions?
We do have a bunch of questions. So I'm just going to start off by saying that there were a few questions around AVOs and a discussion about how it's quite disappointing that you need that level of proof. And Alintia had put in the chat that they're also accepting letters or reports from doctors, counsellors, caseworkers, domestic violence services and community agencies, or statements, letters or statutory declarations from both yourself, family members, friends, and possibly the community workers that are here today.
Yep.
And
Perfect.
then there was a question about, aside from an AVO and being assessed by a social worker at Centrelink, what other types of evidence can we provide to prove the abuse? Sorry, that's what I just answered. So all of those other statements and statutory declarations. And then there was someone seeking confirmation. Can Centrelink really consider someone as part of a couple for payment purposes, even if they are living elsewhere?
Yes.
Yes.
So the mere fact of you living in the same house is not a deciding factor of whether you're in a relationship or not at all. You could be living in a completely different country to your partner, and Centrelink will treat you as though you are a member of a couple, and you will be paid according to getting that payment, that partnered rate, and the income and assets of your partner will be taken into account and will affect your payment. So you don't even have to be living in the same country to be considered a member of a couple.
Okay. And I think in terms of the case study, there was, in that situation, are we assuming that the DV victim survivor is continuing to stay in the relationship, wanting to stay, unable to leave? Oh, sorry, I think that was just in regards to you speaking about people separated under one roof and living, but still staying together. And
there's all sorts of reasons why people might stay together in the same house but no longer be in a relationship. And you know, there's lots and lots of different reasons why you might stay. Yeah, so I'm not sure that I answered any question there.
That's right. I think the way that I asked it was a bit confusing. In the situation where a victim survivor is assessed as not being a member of a couple for a special reason, how does Centrelink ensure that the higher payment rate does not simply end up being taken away by the persecutor due to financial abuse?
So that's going to be, that's not something that Centrelink can control and manage. At the very end of this, or very close to the end of this session, we're going to have a slide that talks about how to keep yourself safe when updating Centrelink with your details and changing your relationship status and things like that at Centrelink. And it's going to be, maybe you will need the support of other organisations to do it as well. It might be that you will need to, Centrelink can't do anything about whether your bank accounts are secure. Your client, or you might need to help your client to do that. Centrelink can't do anything about if permission has been granted to the perpetrator to talk to Centrelink and get all information from Centrelink and get has all passwords to someone's Centrelink or MyGov account. Centrelink can't do anything about that. It's you need to change the passwords. You need to change the access. You need to do that potentially in order to have that financial, that money safe. But that's a conversation you can have with a Centrelink social worker. A Centrelink social worker is going to be able to take your client through what's needed within the Centrelink system and what they need to do within the Centrelink system in order to keep your clients safe and in order to keep your clients' finances safe. Okay, so the next session is all the sorts of questions that can come up when there's children involved, and they can impact in a whole load of different ways. So if there is a dispute about how much time the child or the children spend with each parent or guardian, then that can impact your payment. It's disputed care, and it can impact how much payment you get and what payment you get. If a parent or guardian is in hospital for a period of time, or the child goes to stay with, say, grandma or grandpa for the Christmas holidays, that can impact your payment. If the child has been removed without consent and is not being returned after a visit, that impacts your payment. If there's informal arrangements about, where the child is staying that aren't formalised, that's not set, that can impact your payment. And if there's issues with getting child support, applying for it, or risks involved in applying for it, or getting that money, even if it's been assessed as having to be paid, that can impact your payment as well. So there are two different types of payment that come into play when you're looking at children. You've got the family tax benefit payment. That payment can be split. As long as you have 35% of the care of a child, then you get 35% of the family tax benefit, okay? And the other person will get the remainder, okay? So that payment can be split between two houses. But parenting payment, youth allowance, JobSeeker special benefit can only go to one person. So if you're getting any of those payments, with an acknowledgement of the care that you're providing a child, especially that parenting payment, then only one parent gets that if the child is shared between two households. So when they're looking at who is it that gets that payment and how much do they get, with the family tax benefit, they're looking at who is the primary carer, okay? They're looking at who has that greater responsibility, who's got the decision-making part of it, who's looking after their daily needs, who's making the medical appointments and other appointments, who's taking the kids to school, who's doing all of that just day-to-day care and decision-making for the child. When you're looking at the parenting payment, then you're looking at who has the legal responsibility for the child, who's providing that, it's that principal carer, who's providing the day-to-day care, welfare and development, okay? And it's the one that is the principal carer that gets the payment. So if there's disagreements about care arrangements, then you need to be talking to Centrelink and you're arguing your case with Centrelink, yeah, about who has the care and showing that evidence. Because the thing is that even if there's a court order that says this is how the care is split, this is where the child is, they're not going to be paying a Centrelink payment based on a court order. They pay a Centrelink payment based on what is the care that is actually provided. Where is the child actually spending their time? The court order might give some evidence towards it, but if you're not complying with the court order, then they won't pay based on a court order. They pay based on what the actual care is that's provided. So here's one example. We have a client who left a violent relationship, took her kids with her, and the husband constantly demanded additional days, was constantly keeping the child for additional days, or was threatening to change the child support or stop paying it completely unless he was given those extra days and that extra time, and was just continuing that psychological and physical abuse even after the relationship ended. And our client was constantly trying to keep Centrelink up to date and constantly trying to tell Centrelink what was happening. But remember, family tax benefit is shared between households and it's based on who has the children 35 or the child 35% of the time. As long as you have that child 35% of the time, you get some of that family tax benefit payment. And she ended up getting a Centrelink debt, and she ended up getting a really significant one, a $17,000 Centrelink debt. So just keep in mind that 35% of a fortnight is 4.9 days. So the moment your client drops below 5 days, they lose their eligibility for the family tax benefit. But every day change also changes the rate of family tax benefit that they might be getting. Okay. So it's really, really important to track and manage and keep Centrelink up to date with those changes in the care arrangements, because it can result in really significant debts. And it's really hard to keep track of sometimes. So another one of those concepts that's really important with Centrelink is disputed care. And disputed care is when there is a formal care arrangement. It can be a consent agreement, or it can be a court order. And when that percentage of care in a shared care arrangement changes, so there's that formal arrangement and the percentage of care changes without the consent of one of the parties, when the care of the child changes from one parent to the other without consent of one of the parents, or when it was previously sole care, but it's become shared care without consent of the parties, then Centrelink have to be updated. That court order, that consent agreement, you're not paid on the court order or the consent agreement, you have to update Centrelink or you risk a debt, okay? If you tell Centrelink that there has been this change without consent and that you are taking reasonable steps to enforce that court order or that consent agreement, okay, then it might be that you be able to continue receiving your payment for a period of time while you're trying to get that care returned to what it was meant to be. Okay. So it's not where there's just a disagreement about the facts. It's where there is that formal arrangement, formal care arrangement, and there's been a change without consent, and you are taking reasonable steps to get it returned to what that formal arrangement was. It's also different to where there's been an abduction and the child is missing. So if the child has been abducted, if the child has been completely removed from the care of one parent without consent, and it's not just a change in the percentage, it is they've been completely removed from the person who has that legal responsibility for the child, and they are missing. As long as you tell Centrelink within 14 days of that child being removed without consent, and that's not removal by the department, it is removal by the other parent without consent. And as long as you're taking reasonable steps to recover the child and you show it to Centrelink, so you're reporting it to the police, you're taking out a recovery order, you're trying to get legal advice through legal aid or a community legal centre or a private family law lawyer, then you should be able to continue receiving those payments, the parenting payment and the family tax benefit, for a period of time while you are trying to get that child back and returned to you. If the other party who's taken the child claims a Centrelink payment when they've removed that child without consent and you're taking reasonable steps to recover them, then Centrelink shouldn't grant that payment as long as you're taking reasonable steps and as long as you've told them within 14 days of the event happening. Okay, but if the child has been removed by docs, or if there are new family court orders or consent orders, then your payment will cease. If you don't tell them within 14 days, then once Centrelink find out, your payment will cease and you'll have a debt raised back to the date that the child was taken without your consent out of your care. You need to be updating them. You need to be talking to Centrelink. You need to be telling them what's happening. So Jenny had a custody dispute and there were family law orders that the child was to live with Jenny. The ex-partner left the state with the child, completely refused to return. The ex-partner told Centrelink he was the principal carer and Jenny's parenting payment, single and family tax benefit were cancelled. She was left without any income whatsoever while trying to fight through the courts to have her child returned because she didn't tell Centrelink within 14 days what had happened. Okay. So if the perpetrator gives false information to Centrelink about the level of care, about who has care, about what's happening with the child, Centrelink, if there's any change in that, Centrelink should be contacting the nominated principal carer before a payment is cancelled. So Centrelink should be calling your client, should be letting them know that someone has called or someone has said that they have care of the child, just to check in and give them an opportunity to prove that they have care of the child. Okay. It also gives them an opportunity to claim a different payment, claim JobSeeker payment, claim youth allowance, claim age pension, claim a different payment if it is actually true and they no longer have the care of the child. But if payment is reduced or cancelled, then contact us, contact another community legal centre that does advice in social security law. Social workers are the ones that make the assessment about who the principal carer is and who has the care of the child. Okay, but the principal carer isn't always contacted before the payment is cancelled, but they should be, especially when there is a dob-in about who has that care of the child and saying that someone's been lying. Okay. So when when a child is temporarily absent from the parent's care, it's possible that the payment can continue for a period of time. And it's not necessarily a long time. Parenting payment continue for 8 weeks and FTB can continue for 4 weeks. The sorts of situations where this might come up is where, say, someone has gone to stay with friends or relatives over the holidays. It's the Christmas holidays. They've gone to stay with grandma down by the beach for a month. Yeah. It might be that the parent is in hospital, or the parent has had to travel for work for a period of time, or all sorts of reasons why a child may have to live temporarily with someone else, but only for a temporary period. And you can keep getting that payment for those short periods of time, but you need to have an end date. It needs to have a clear and defined end date of when the child will be returning back to the parent's care or the principal carer's care. There's also a situation, and it's a relatively common situation, where you can have informal care happening. And informal care is one of those private arrangements that happen between a parent and another party. It might be between people, kinship groups, between friends, between extended family members. Okay, it's usually grandparents or other family members and friends, and family friends. You can keep getting your family tax benefit even when the child is in one of these informal care arrangements and is staying with other people, but it completely depends on the details of what's been going on. And the two terms that you're looking for is delegation of care, where you're delegating care to someone else, but you're retaining a whole load of parts of those parenting responsibilities and decision making, or a change of care where someone else is taking on some of that role. And that will depend on whether you can keep getting that family tax benefit or not. And it can be quite difficult to determine. It really is a subjective decision. It really is a case-by-case sort of situation where they're going to be asking lots of questions and lots of information about the detail about what's been going on before a decision can be made. So a delegation of care is where the care arrangements are temporary. They're short-term. There's a defined or planned end date where the principal carer, the parent, is still meeting all those financial costs of the care of the child, and where they're still making all of those important big decisions about the child and about the child's life, health, education, all of those major things. If that's the situation, then the parent or the principal carer keeps the family tax benefit. However, if those care arrangements don't have that defined end date, if they're not temporary, they're not short-term and don't have an end date, or if the principal carer is no longer making those decisions, then the new carer is probably going to be entitled to family tax benefit, and they'll be able to get it after 4 weeks of having care of the child, or the moment that that change of care happened, if it was earlier. Yeah. So think about Lisa. This is a way to think about it. So Lisa was in an abusive relationship. She had to leave her home, and she took her kids with her, but she didn't have any stable accommodation to move to. Okay. So what she did is she left the kids with the paternal grandparents while she tried to get accommodation. Okay. She signed a lease, but she couldn't move in straight away. She had to wait 3 weeks before the lease would start, and she's crashing with friends while she waits. She's talking to the kids every day. She's sending money. She's covering expenses. She's making all those major decisions. And as soon as she can move in, those kids are moving in with her. Okay, so she's got a really defined end date. She's got a lease that starts in 3 weeks. She's signed it. So that is a delegation of care. It hasn't changed. It's got that defined end date. She's still making those decisions. But consider the situation where she's left the abusive house. She's taken the kids. She's trying to get accommodation. She's still left the kids with the paternal grandparents. She's trying to get a tenancy, but she can't. No one will rent to her. She can't get a lease. She's crashing at a friend's house. She doesn't know when she's going to be able to get a lease. She doesn't know when she's going to be able to get secure accommodation. She's talking to the kids. She's covering their expenses. She's making the decisions, but she has no idea when the kids are going to be able to live with her again. Because there's no defined end date, we've got that change of care, and the grandparents are probably going to be able to claim and receive family tax benefit. So it's that unable to secure that tenancy, unable to get that defined end date. Now, one of the other big things when there are kids involved is claiming child support and getting child support. And we can't advise on child support. We can't advise on the child support system. If you've got issues with, the child support system or getting child support, we can't advise on it. We can advise when child support impacts your family tax benefit. And we can talk to you and advise you on the family tax benefit side of it. Because one of the things that it's really, really important that you are aware of when you're talking to your clients and making sure they're getting all of the financial support they can get is that a part of the rules for family tax benefit is that a person who's getting family tax benefit who doesn't live with the other parent must claim child support, must seek child support from that other party. It's called seeking maintenance action. It's taking maintenance action. Okay. And if you don't take maintenance action, if you don't claim child support or seek child support, then you don't get the full rate of family tax benefit. You only get the base rate. You get a really much, much, much lower rate of family tax benefit. It's thousands of dollars a year that your client's going to be missing out on. Now, a lot of people won't claim child support when there's a family and domestic violence involved because there's that history of violence, there's fear of that retaliation. Maybe they are unable to locate the other parent. Maybe they don't know the identity of the other parent. That's not so much the family and domestic violence, but there can also be cultural beliefs. But that family and domestic violence, that history of violence and that fear of retaliation can be seen as a reason why you should be exempt from seeking maintenance action, exempt from getting child support. And it is the social workers or the Indigenous specialist officers that will make that decision about whether you should be exempt. And if you are exempt, then you will get the maximum rate without having to take that maintenance action. But if you're exempt, if you don't have to seek maintenance action, but you start getting child support, don't forget to tell Centrelink. You really, really, really have to tell Centrelink about any child support that you get because otherwise you may get a debt, okay? So one of those questions I would really highly recommend that you actually ask your client is not, are you getting family tax benefit? Don't ask that question. Yes, ask that, but don't only ask that question. Also ask, how much family tax benefit are you getting? And then check it against the rates on the Centrelink website about the base rate and the maximum rate. And actually just check, are they only getting the base rate? Because a lot of people have no idea that they're only getting the base rate, and you might be able to help them to increase their rate of payment for the family tax benefit. So the other way where Centrelink and where child support can impact your family tax benefit is you've sought child support, you're getting it, and you're going through the child support agency and it's still not being paid. So there is a formal amount that Centrelink believe that you're entitled to, and they will make the assumption that you're receiving that amount, and that child support is considered income for family tax benefit purposes, not necessarily for, for parenting payment, but for family tax benefit purposes, child support is income. And that child support can push you over an income bracket, over an income limit, and reduce your family tax benefit payment. But you might find that you've got people who are in this situation are assessed to be receiving this amount of money, but it's not turning up in their bank account. It's just not being paid, but their family tax benefit's being reduced as though it is. So what you can do is you can contact Centrelink and say, look, please don't pay me my family tax benefit based on what I'm entitled to because I'm not getting what I'm entitled to. Please pay me my family tax benefit based on what's dispersed, on what I actually receive rather than what I'm entitled to. Now, you can only do this if your child support's being collected by the child support agency. If you're on private collect, this is not an option for you at all. Okay. The other thing is that you have to tell Centrelink about all the child support you get when you're on the disbursement amount, because otherwise you might get a debt. Okay, so just be aware you do have to declare that money to Centrelink, or you might get a debt, and you can only do this when you're going through agency collect.
So a question from the earlier part of this session was, is the percentage of care for FTB based on days or nights of care?
So this is one of those ones where it is generally based and it's assessed on nights where the child is sleeping. If you're in a situation where maybe they're sleeping at someone's house, but for 8 hours, but for the rest of the time, every single day they're in the care of someone else, I'd be getting legal advice. Yeah, get legal advice on that one.
Okay. There's been a bit of general agreement about how hard it is for the person experiencing DV to maintain all these updates and changes with Centrelink and what that means for that person, and the possibility or the very high likelihood that those things won't happen, all of those checks and balances and changes and reporting. So, okay. What if a client does not want child support payments because the other party insists that child spend time with them in an unsafe situation?
If you've got a situation, and tell me if I'm misunderstanding this. If you've got a situation where someone does not want to seek child support, and as a consequence, they've been placed on the base rate of family tax benefit because they have chosen not to take maintenance action, then you need to be looking at whether they might possibly come under one of those exceptions and whether an application can be made for an exemption from seeking maintenance action. So you're looking at, is there a risk? Is there a history of family and domestic violence? Do they fear that there may be a risk if they were to seek maintenance action, seek child support? Is the whereabouts of the parent unknown? All of those exemptions from seeking maintenance action, that's where you go. There's no exemption from choosing not to seek child support. You've chosen not to seek child support, that's fine. You can make that choice. Centrelink does not accept that as a reason. You need to come under one of those debts. That's a 2-hour long session on debts.
Which is coming up in March. 14 days doesn't really seem long enough to inform Centrelink, given there is so much going on, and some advocacy to extend this would help. Agreed.
Agreed. Our peak body, Economic Justice Australia, does a lot of advocacy about, seeking changes to the Social Security and Family Assistance systems. So if that's something that you're interested in, I'd be getting in touch with them. What their priorities are at a given time, it's them that you need to be chatting to.
There's lots of commentary, but not specific questions as such. There is a request to clarify what do you mean by the opportunity to claim different non-carer payment if information ends up being correct in terms?
So it might be that you say if in terms of you might have a client who's receiving a payment based on care of children. It might be that they're receiving parenting payment single, family tax benefit based on the care of the children. And it might be that they aren't actually eligible for that payment anymore. Whether, there's been an adjustment in days and maybe someone else has become the principal carer or the primary carer of the child, and maybe they can no longer get parenting payment single, or maybe they don't have 35% of care of the child anymore for family tax benefit. Centrelink will contact them and give them that opportunity to lodge an application for an alternate income support payment, like JobSeeker Payment or like youth allowance or a different income support payment, if they actually, in fact, no longer have the type and nature of care of the child that gives them eligibility for that payment.
To add to how to determine the percentage. I might have missed this comment, but does Centrelink consider the impact of DV when determining care arrangements, similar to the considerations re being in a relationship?
What they consider is who has care of the child. Where is the child? Who has care of the child?
Okay. I think that's it. If you need further clarification, please put your questions in the chat and we'll try and be clearer in the next question session.
Cool. So we'll have a break now. All right. Okay. Thanks, everyone. Welcome back. We're now going to have a few slides that are just looking at some really specific payments and some really specific things that you might be needing to help your client with. We're looking at crisis payment, urgent payment, and special benefit. So crisis payment is usually that one, that Centrelink payment or that Centrelink relationship that people first think of when they're thinking of domestic and family violence. It's an additional top-up payment. It's 1 week of their primary income payment. So if they're on JobSeeker payment, it's 1 week of JobSeeker. If they're on parenting payment, it's 1 week of that parenting payment. Okay. To get crisis payment, you must already be on a Centrelink payment. You have to be on that primary income support payment before you can get crisis payment. Okay. So you also need to be in severe financial hardship as well. Okay. So the thing about it is, though, that you might have someone who you are assisting who is escaping domestic and family violence, and they're not on a Centrelink income support payment. They just need to get that application in for a payment before they put in that crisis payment. They can do it both at exactly the same time. Centrelink will process the application for that primary income support payment, that parenting payment, JobSeeker payment, you know, any of those payments, and then they'll process the application of a crisis payment. But that crisis payment has to be linked to an income support payment. You can't just get it just on its own, okay? So the way that you get that crisis payment, or the people that are eligible for that crisis payment, are people who have left home because of domestic and family violence, or where the perpetrator has been removed from their home because of family and domestic violence. People who are recently homeless, recently released from prison, and recently arrived as a refugee or a humanitarian visa holder can also get crisis payment, but we are talking here specifically about that domestic and family violence payment. When there's domestic and family violence, you can actually lodge 4 applications in 12 months. Okay, they recognise that it can take quite a few times for someone to leave a relationship, or they recognise there can be more than one incident in a 12-month period, and you're not restricted to just 1 application in 12 months. But social workers are the ones that make the assessment about whether you are eligible or not, and they're meant to use judgment when there's trauma involved. But you are probably going to have to provide evidence that you are eligible for the payment. They're not going to take someone's word for it. That you are going to have to provide evidence of some description. So you need to be clear, though, that when you're contacting Centrelink, that you're contacting about crisis payment. You need to be using those words, saying that you are contacting about crisis payment. Okay. So there are strict time limits, and they're really, really strict time limits on getting crisis payment, and they can be very short, you know. So if you are the person, or your client is the person that's staying in the home and the perpetrator has been removed and is unable to come home or is establishing a new home, okay, then they have to contact the person claiming crisis payment needs to contact Centrelink within 7 days of them being removed. Now, they then, from the date of contact, have 14 days to lodge the application. So those times are really, really short. You know, 7 days to make contact, making sure you're using the words, I'm contacting about crisis payment. You have to be using the words crisis payment. Otherwise, it doesn't necessarily, you won't be recognised as having contacted within the 7 days. And then you need to get that application in within 14 days of that contact. And you're going to have to show evidence that you're eligible. So you have to show that the perpetrator cannot or will not come back. So you might need to show an ADVO or something similar. You might need to show statements from support workers or doctors or schools and things like that. You have to show evidence that they have left and will not come back. Now, if you're the one, if your client is the one that has left, you know, the property and the perpetrator has stayed, it's still a 7-day time limit, but it's 7 days from the day or the moment they realise that they can't go back or they're not going back. So you might find that you've got someone who's left and has gone to stay with friends. You know, there's been an incident, they've left the house, they're staying with friends, they've gone to a refuge, they've just left the house, always thinking they'd just go back the next day or back in a couple of days when the perpetrators calm down. And then they've realised, actually, no, I can't return home. And it's from that moment, it's from the moment, that day that they realise or they decide that they can't return home, that's the day that the 7 days start. Okay, so you have to ring, you have to contact Centrelink within 7 days of that day. And then you've got 14 days from then to lodge the claim. You need to be showing that extreme circumstance. You need to be showing that domestic and family violence occurred. You need evidence of that. You need to be showing that you've left the house, that it's unreasonable to return. You need to be showing that you're establishing or have established or intending to establish a new home. Okay, you can't just go, yeah, I've left home because of domestic and family violence without proving that that domestic family violence happened. Okay, so you need to also be aware, because this can upset a lot of, it can upset the victims, it can upset victim survivors. Perpetrators are also eligible for crisis payment because they may have left the home and been unable to return due to domestic and family violence. Okay, so they may also be eligible for that crisis payment. Now, you also might be helping people who have experienced that domestic and family violence, but who are not eligible for crisis payment. You cannot get crisis payment if it's an ex-partner who doesn't live with you, who has perpetrated the violence. Even when an AVO may have been put in place with an exclusion order, if they weren't living with you, then you can't get crisis payment. It might be, the daughter's boyfriend who occasionally stays overnight, might have a key, but doesn't live there. It might be a family member, but someone's income and assets are above the Centrelink threshold. They can't get that income support payment because their income and assets are too high. Or it might be where the contact has been made too late, where it's been more than 7 days from the removal, or more than 7 days from deciding you can't return home. Okay. In all of those instances, you just can't get crisis payment. It's not payable. Okay. You might be able to help someone to get an urgent payment as well. Just be really, really aware with an urgent payment. It's an instalment of your existing payment. You're paid it in advance. It means you're going to get less your next pay. You're going to get a reduced payment your next fortnightly payment, and because you have to pay it back. It's not an additional payment. It's not like crisis payment. It's an advance on your payment. It has to be paid back. All right. So you're eligible if you're in severe financial hardship due to family and domestic violence, and you can get it twice in 12 months. There are some exceptions. You might be able to get it more, but some limited exceptions. But you can just generally, as a rule, you can only get it that twice in 12 months. And you can apply online through MyGov. Okay. Now, special benefits are really, really important one for people to know about and consider if you're helping people where there is no other payment that you may be eligible for. And generally we see this most often when people are newly arrived residents, they've recently arrived, recent migrants to Australia, or they've only recently received their permanent residency visa. And as a consequence, they have what's called a newly arrived residence waiting period. For most payments, there is a waiting period that new migrants, people who've only recently received a permanent residency visa, have to sit through before they can get access to a Centrelink payment. A lot of the payments have different waiting periods. It's worth getting advice on this if you've got someone who is in this situation. But if you have someone who's on a 4-year newly arrived residence waiting period, they may be able to get access to special benefit, which is that payment that you can get when there's no other payment that you may be eligible for, as long as there has been a significant change in your circumstances that was completely beyond your control and all other eligibility criteria are met, which we're not going to be going into today due to time. Now, when that significant change in circumstances is a relationship breakdown due to family and domestic violence, then that significant change can happen at any time after you've arrived in Australia, and it doesn't have to have happened after getting your permanent residency and after starting your waiting period. But for a lot of other situations, that significant change can only have happened after getting your permanent residency. Domestic and family violence, they will push it back earlier. And as long as that significant change, that breakdown in the relationship due to family and domestic violence happened in Australia, then that can be considered when looking at whether someone might be eligible for special benefit and they don't have to sit out that 4-year waiting period. It's a really important application, important payment to remember. A lot of people don't know special benefit exists. It's an important payment to remember, an important application to lodge. And if your client's rejected, get some legal advice. Okay. So the other thing as well, if you've got someone who became a lone parent after getting their permanent residency, then they might be able to get parenting payments single without having to wait out the 4-year waiting period. But if they became a lone parent before getting their permanent residency, they won't get access to parenting payment. It's only if they became a lone parent after getting permanent residency. Then they won't have that 4-year waiting period. So you might find that you have a situation where the adult applicant isn't eligible for any payment. It's where there's no newly arrived residents waiting period, there's just no payment at all that they're eligible for because they're on a visa that gives them no access to anything. This situation isn't appropriate for people who are on that waiting period that are on the permanent residency. This is only for people where they can get no access to any Centrelink payment whatsoever, waiting period or not. Have a talk to them and ask them if their children are Australian citizens or their children are permanent residents. Because when the parent who has the care of the child is on that temporary visa and they have no way of supporting the child at all, and the child is an Australian citizen or a permanent resident, then the child may be able to get and may be eligible for a payment. And that child may be a 1-week-old. You know, that child may be 5 years old. The child may be eligible for that special benefit payment if the parent is on that temporary visa. So lodge the application in the child's name and pop that application for special benefit in. The money goes to the parent until the child's 18 or until the child is eligible for youth allowance. Okay. If the parent becomes eligible for a payment, gets that permanent residency, then the child is no longer eligible for the payment and that child's payment will stop. Okay. But the parent will be able to apply for special benefit in their own right and ask for that 4-year waiting period to be waived. Okay. And the eligibility for special benefit changes with kids depending on age and all sorts of other things. It can be it's a complicated system, but just be aware it's there and help them lodge the application in the child's name. Okay, Any questions?
Yes. There's a few just on crisis and urgent payments. One is, well, I think we answered this in the chat, but does someone need to be already receiving a Centrelink payment to be eligible for a crisis payment?
Yes, however, that's a technicality because you can lodge the application for the payment and the application for crisis payment at the same time. But you cannot get crisis payment unless you're on a income support payment.
And I think there was a question about how long that might take. So if you did lodge them both at the same time, how quickly would you get a crisis payment, do you reckon?
There's no set time. You can say if you're saying that you're in severe financial hardship and you're showing that you're in severe financial hardship, you can ask that the application be prioritised and be processed as quickly as possible. But I'm not going to put a time on it, I'm sorry.
All right. And can you get both crisis and urgent payments at the same time?
I don't know. It's not something I've looked into.
All right.
My advice with that one would be lodge the application and find out. Yeah, apply. Test your eligibility.
Apologies.
No.
Oh, okay. This might have already been asked, but does Centrelink require evidence of FADV in terms of the caring for children and if you apply for maintenance exemption?
So the social worker makes that decision, yeah, and the social worker will, if you have a support worker, a letter of support from you guys as support workers, as community workers assisting your clients, it can be used as evidence towards it. If you're a part of a refuge and your client is living in the refuge, in a domestic and family violence refuge, that might be seen as evidence. They're not going to, Centrelink can't make legal decisions based on, someone's word alone. It's going to be that conversation with the social worker, and they'll be able to let you know what evidence might support your application if you haven't provided that evidence, enough evidence.
Okay, and this brings us to another question that was asked earlier. Is there a pathway to appeal an adverse decision made by a Centrelink social worker?
Sure. Oh, well, no, the Centrelink social workers don't make decisions. What they do is I know I've been talking in terms of they make the decision, and I'm sorry, that's confusing language, and I'll try and adjust my language from here. So Centrelink will make the social workers will look at whether they think that someone has experienced family and domestic violence or should be eligible for a maintenance exemption, and they'll make that recommendation, and a Centrelink officer will make the actual formal legal decision. And that formal legal decision can be appealed, and we'll be talking about that a little bit later on, but not a huge amount. There's a fact sheet on our website, a link to a fact sheet on our website about appealing Centrelink decisions. So pop on there and have a look at it. It's much, much more information about appealing Centrelink decisions. So that actual decision that's made can be appealed, and you can provide evidence to say that that social worker's recommendation is incorrect.
Okay. Here's a question. Could a temporary visa holder be eligible for a crisis payment as they are not eligible to receive any Centrelink payment?
No, because you cannot get crisis payment unless you're on a primary income support payment. So you might find that someone who's on a permanent residency visa, look, visas can be really complicated. There's one or two temporary visas where you might be eligible, and it's a very, very complicated area. We have in the past run 2-hour sessions that gave a brief overview of newly arrived migrants and issues facing them. So it's a very complicated area. So you might find that you've got someone who's on special benefit. That's a primary income support payment, and they can get crisis payment. But unless you're on that primary income support payment, you can't get crisis payment.
Okay, and this is just about the processing time, but it's just a little bit of a twist. So if the processing time isn't kind of set for a crisis payment, and if the client is no longer in crisis or acute financial distress by the time that the claim is processed, will the client still receive the payment?
Your eligibility for an application for a payment is based on your eligibility on the day you lodge that application. So, you know, they're looking at whether you're eligible on the day you apply.
Okay. Okay, and here's another one. Can a parent who's on a temporary visa, sorry, that just moved, claim for child support if a child is Australian in the case of domestic violence?
Once again, that's child support. I can't do child. I don't know child support.
Sorry.
No, you're good.
Okay. Well, that's it for the moment. I think we have one more question time, so I'll dig out the rest and pull them up.
All right. So we will try and race through the rest. So we're now talking debts. And this is a really, really big one for people who are experiencing family and domestic violence. It's one that we see a lot of. So common reasons why someone might go to debt due to family and domestic violence, where, you know, the victim survivor is lumbered with this debt because the perpetrator lied about or hid their income and assets, or maybe the perpetrator stole money, or they forced the victim survivor to hide the relationship or hide their income, or maybe the child wasn't returned after visitation, and Centrelink wasn't updated within 14 days. Other issues can be that member of a couple where you're paid at the single rate, the higher rate, but Centrelink make that decision later on that you actually should be getting the lower partnered rate. That change in percentage of care and things like that. And it's also, you know, important to know that there can be that risk of prosecution if Centrelink decide that there was Social Security fraud. Okay. So this is what debt notices can look like. You'll see in the top right-hand corner there the amount of money that Centrelink have said that you have been overpaid that you weren't entitled to. Underneath that, there's the date that you need to get into the repayment plan by. So have a look on the left-hand side there, and it gives you a little bit of information. It doesn't give you a huge amount. So it says here, you're a member of a couple. Yeah, you're entitled to the partnered rate and not the single rate that you are paid. And as a result, you've been overpaid for, you know, in this instance, it was 15 years. And as a consequence, you've got the $65,000 debt. It doesn't say who the other member of the couple is, doesn't give you the name of the person they say you're in a member of a relationship with. It doesn't say why they believe that you were in a relationship when you have declared that you were not. It just gives you those bare facts. Okay. And so that, you know, and that's the document. It's a document like that your client's going to get. So first things to think about when you get a debt, and it's really important, you've got to contact Centrelink and you've got to enter into a repayment plan, or you can ask for the debt to go on hold for a period of time. And you've got to do it before that date. So remember on this letter, that top right-hand side there, that date underneath the dollar value of the debt, that's the date that you need to be entering into your repayment plan by. If you don't contact them and enter into the repayment plan and you're on a Centrelink payment, they will start deducting the standard 15% of your Centrelink payment as a repayment of the debt. Okay? And if you contact them, you might be able to negotiate that lower. You know, you might be able to get it even as low as, say, $20 a fortnight. Okay. If you don't enter into a repayment plan, Centrelink can get a garnishee order. They can contact the workplace and start garnishing wages. They can force sale of assets. It takes a while to get to that point. That's not an immediate thing. It's not going to happen the day after your debt was due. You just need to be aware that that can happen. And if you don't get into that repayment plan, they can charge interest, and your debt will just slowly increase as interest keeps getting charged. The thing to be reassured by is that merely getting into a repayment plan is not admitting that you're liable for the debt. It's not admitting that you should have to repay the debt. What it's doing is holding off those interest charges and all of the other consequences. It's just giving you time to get advice to see whether you can appeal, you should appeal that debt. Because you should never, ever appeal a debt without getting advice first, because debts can go up on an appeal. You should always get advice first before lodging any appeal. One of the really common ways that we see people who are experiencing family and domestic violence get Centrelink debts is where the perpetrator doesn't do their tax return. And that will often happen. A relationship will break down, the victim survivor will leave, and the perpetrator won't do their tax return because they know that if they don't do their tax return, then the victim survivor is going to have every single cent that victim survivor received in family tax benefit while the relationship was happening raised as a debt. So if either member of the couple doesn't do their tax return, then all of the family tax benefits are recalled as a debt, and the person whose bank account it was paid into has to repay it. Okay? And that can often be used by the perpetrators. Now, if the relationship has broken down, if they are no longer together, then you can ask for that debt to be written off, and so that the person who has the debt raised and originally received the money doesn't have to repay it. Once the perpetrator does their tax return, sometime in the future, that debt will be recalculated. Okay? And it might be that someone may still have a small debt or may not have any debt at all, but it just means that it's not there, it's written off until the perpetrator does their tax return. But if the victim survivor hasn't done their tax return, then, you know, they need to do their tax return. You know, if they haven't done their tax return and a debt's raised, then they have to do their tax return. Yeah. Okay. Now, if you have someone who has a debt, now it might be family domestic, it might be a FTB debt, it might be parenting payment debt, it might be JobSeeker payment, it might be youth allowance, it might be Aus study, special benefit, any of those payments. If a debt has been raised because Centrelink has said that they have been paid more money than they are entitled to, and there is family and domestic violence, then it is possible for that debt to be waived under special circumstances. It's possible for any debt to be waived under most debts to be waived under special circumstances. It is, once again, a really, really complicated area of the law. If you're looking at learning more about debts, Centrelink debts, come to our next 2-hour session in March, because this is a very, 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 very brief snapshot. But if you have someone who has a debt and there was family and domestic violence, it is possible to ask for that debt to be waived due to special circumstances. Special circumstances are unusual and different compared to what people on that payment would normally be experiencing, where someone in a particular segment of society would normally be experiencing. And they look at family and domestic violence, they look at the experiences of the victim, they look at previous relationships, they look at the childhood, they look at, you know, whether someone's lost custody due to the actions of the perpetrator, they look at whether maybe someone shouldn't be considered a member of a couple. They look at it's more powerful if that family and domestic violence was happening during the debt period. However, they do look at other periods. They look at all other time periods as well. Centrelink error can be a special circumstance if someone reported the loss of custody or reported the change of relationship, but it actually didn't get recorded on their file and they got paid the incorrect amount. So that can be considered a special circumstance. But one of the really big problems with special circumstances is that Centrelink cannot consider whether a debt can be waived under special circumstances if there has been what's called knowingly involved. And knowingly is where someone has deliberately and knowingly behaved in a way in order to get more money than you're entitled to, or knowing that, choosing to behave in that way, they would receive more money than they are entitled to. Okay. Now, and it's the person receiving the money or someone else. So if if the applicant has been forced to lie to Centrelink by the perpetrator in order to get more money, there's knowingly, and special circumstances can't be considered. If the perpetrator lied to Centrelink themselves, knowing that their partner would get more money, there's knowingly, because it's the person receiving the money or someone else. Yeah. So that's a big barrier for people with family and domestic violence to be able to apply for and get special circumstances consideration for debts. There is legislation that is currently before Parliament. It's gone through one of the houses. It's going before the second house currently. That is going to remove knowingly as a barrier for special circumstances appeals for debt when there is family and domestic violence and the perpetrator might have done it, or there might have been coercion and forcing and things like that involved in why the person was receiving more money. So when you're talking to your clients, if you believe that knowingly might be an issue, you might want to consider delaying appealing any debts until after that legislation is passed. There's no time limit to appeal a debt to the authorised review officer, the first level, and there's no time limit to appeal a debt from an authorised review officer to the administrative review tribunal. So when we consider this situation here, Marta was married for 10 years. He worked as a sales assistant. She took care of the 3 kids. She had very little English. He was violent, controlling. He managed all the finances. He did all of the Centrelink stuff. He was her nominee. She had no control, was not able to manage the money at all. He never explained to her what was going on or how Centrelink worked. She eventually got out of there. She eventually left. She took the children. She was supported by a refuge to access Centrelink payments and get rental. She starts getting everything back on track, and then she's notified by Centrelink that she's actually got 2 debts, and those debt periods cover the time that she was living with her husband. So before appealing the debts, Marta needs to contact Centrelink and get those payments reduced. Get those fortnightly repayments reduced, or ask for the debt to be put on hold while she's gathering evidence and trying to find out what's going on. Her advocate, her lawyer, whoever's helping her, or she might choose to lodge a freedom of information request to try and figure out what was going on, what was happening, where the debts have come about, why the debts have come about, and what was happening at the time, to see if maybe the perpetrator underreported income or what was going on. Okay. And it might be that that conversation will happen about that family and domestic violence, and about whether maybe it's appropriate to appeal that decision to raise the debt and ask for the debt to be waived due to special circumstances when looking at, his threatening behaviour, the coercive, that domination, that controlling abusive behaviour, and that financial abuse. And the fact that she had very little control over the finances. But in this situation, when it was really clear that there is a very high chance that someone, whether not necessarily her, but him, knowingly behaved in a way in order for her to receive more money than she was entitled to, it might be that we would be advising to hold off until after the legislation is passed, because you might have a greater chance of success. Okay, I'm really running low on time, and I am sorry, everyone. So the other thing that you consider, remember way back at the beginning, we were talking about Section 24, those special reasons why someone should be treated as single rather than a member of a couple. Okay. You can apply that Section 24 retrospectively. Someone may have been paid a significant amount of money. Thinking back to that debt notice where someone was paid for 15 years as single and Centrelink decided they're a member of a couple, maybe consider whether they should be treated as a single rather than a member of a couple during that debt period, because of family and domestic violence. And so maybe that debt could be recalculated and them to be found eligible for that single rate of payment rather than the coupled. Okay, appeals. Most Centrelink decisions can be appealed, but not all Centrelink decisions should be appealed. Okay, I've already said it once, I'm going to say it again. Debts can increase on appeal. Get advice first. Okay, debts can go up, but also people can be prosecuted. So get advice before you appeal any debt, just to make sure that your client isn't going to turn around and go, I had a $500 debt, I've now got a $5,000 one. Okay. There are time limits to appealing Centrelink decisions. It's really, really important that you comply with them, because if you don't lodge your appeal in time, you may not be eligible for back payment. Okay, so when you've got that original decision to reject an application for a payment, to reduce the amount of money you're getting, to convert you from single to coupled rate, any of those sorts of decisions, to raise a debt, then you can appeal. The first level of appeal is to an authorised review officer, and those are your time limits. It's usually 13 weeks from the decision. For some things, it's 52 weeks. Family assistance, it's 52 weeks. Paid parental leave is really short. It's only 28 days. And debts, there's no time limit. Don't appeal it. Get advice. Yeah. If you're appealing from that authorised review officer's decision through to the tribunal, then it's that 13 weeks, but there's still no time limit for debts. Once you've got that first administrative review tribunal decision and you're appealing to the second review by the tribunal, it's 28 days. It's super short. Okay, make sure make sure you know your time limits. They're really, really important. Okay, so if you want support to get Centrelink payments, and I'm so sorry, then you need to make sure you're keeping your Centrelink information safe. Get onto MyGov, call Centrelink, update passwords, and change who has access, change who the nominee is, change who can talk to, because you've got different levels of access that people can have. You might have given someone permission to talk to Centrelink, or you might have someone down as a nominee. Get all of that changed before you change your relationship details and before you change your contact details with Centrelink. Okay, there's some information at that link about how to keep information safe when you're leaving a relationship. Okay, remember though that you often have to update different departments separately. So you're going to have to update Medicare separately, child support separately, other things are going to have to be updated separately. It's not update one and you've updated all. Okay, so make sure you remember that. Now, you can get access to Centrelink social workers. They make a lot of those recommendations and make a lot of those assessments. They're assessments, but they're not that final decision of rejecting a payment, but they'll do the assessments that are used in making that decision. It can be, we know that some people can have difficulty accessing social workers. We've heard that they've significantly increased the number of social workers that are employed by Centrelink now. We're hoping that means it's a lot easier to get, it's easier and quicker to get access to them. You might need to be available by phone. If you're not available by phone, you might not be able to get access to one, and you might need to wait a couple of days, okay, to get one. We've already had someone mention the LVP payments. So these are those there's additional financial support that you might be able to get. These are not ones that we can advise on and that we can assist. They're not Social Security, they're not family assistance. There is the family and domestic violence financial assistance payment for people on temporary visas. Then there's the other escaping violence payment for permanent residents and citizens. And then you've also, remember, there's those victim services payments as well that you might be able to get access to. There are other supports out there. So we're a New South Wales organisation, so our education sessions are New South Wales based. If you need support outside of New South Wales, then you need to have a look at what services might be available in your state. In New South Wales, these are a number of different services that might be available when you're assisting people who identify as Aboriginal and Torres Strait Islander and who are experiencing family and domestic violence as well. We also have our website contains an enormous amount of information, and we hope that you guys are using it and accessing it and getting what you need from it. There is there's a First Nations part of that website, as well as a non-First Nations part. They contain similar information. It's just different layout. Then there's also other community legal centres in New South Wales that your clients might be able to access and get assistance from. The Women's Legal Service, there's a Financial Rights Legal Centre, Warringabaya for people who are women who are Aboriginal and Torres Strait Islander, and Redfern Legal Centre run a domestic and family violence financial abuse service as well. So it's one of the few times that you will get free legal advice and assistance when you're leaving an intimate partner relationship. Any questions? And I'm aware we've only got 5 minutes left, so I'm going to be I'll be as quick as I can answering these questions.
Okay. There's just a few, and I know they're very not very specific, but not totally deep. FDV, but do you know whether bankruptcy removes their Centrelink debt or whether it becomes secured, similar to ATO?
No, so bankruptcy can be quite complicated, but bankruptcy does not guarantee a Centrelink debt is removed. In some circumstances, yes, it will be, and in other circumstances, no, it won't be. I'd be getting legal advice.
Okay. If a caregiver was admitted to hospital involuntarily due to mental health reasons, would this affect the 14 days change of circumstance notification period?
There's a 14-day notification period is set. That's just what the notification period is. If a debt is raised as a consequence of not notifying within 14 days, then maybe those circumstances could be used, and in special circumstances appeal for waiver of that debt.
Okay. And what if Centrelink had admitted an error but would not waive the debt?
So look, going into debts, the debt, as I've said, debts is 2 hours in and of itself. It's enormous. Centrelink error has a whole load of different components to it. We've got a fact sheet on debts on our website. We've got the 2-hour session coming up in March. I'd highly recommend coming to it. If it's sole Centrelink error, then it's treated separately to whether it is Centrelink error, but there's a component of the person receiving the payment maybe, might have contributed to it or might have known might have had an idea about what was going on. There's all different sorts of complicating factors. And if it's family tax benefit, then that's different again.
Okay. And just one final, very short one. Is there a fee for FOI?
No. However, if it is the Freedom of Information Department may have a chat to you and go, actually, no, it's really, really big. Can we sort of talk to you about maybe how we can adjust your question so it's a bit smaller? There is no fee when you're asking Centrelink Services Australia for your documents.
Okay. Thank you. Thank you, everyone, for your questions. All right. Do you want me to take this, Donna?
I think this was where you were taking over. Yeah.
Yep. So people have been talking quite a lot about their services and who they're supporting. If your client might need extra support with Centrelink, you can possibly be authorised as a nominee based on whether or not your client would like that. So here are some links regarding that. Next slide, please, Donna. There are also online appointments that you can make to support your client in their language, there are two things. There's interpreting services that Centrelink will provide, and they can both do documents and speak to your client in their language. There are also digital appointments. So if you can make appointments for your client to get more support about accessing Centrelink and understanding how to engage with them online. And next. This is our client intake line. Please feel free to get in contact with us if you have further difficult questions or clients that you would like to refer. Next. And as we've discussed many times, our website is available. And if you follow us on social media, you can find out more about what's coming up and our Social Security news and updates, and sign up to our newsletter. We have a lot of resources as well as fact sheets, social media, and please complete our evaluation survey. We will also be emailing this to you, and we very much appreciate you attending today, and please come back.
Thank you very much, everyone, for coming along.